Right. So what we're looking at here is the 1832 report on public petitions from the Select Committee, which was chaired by Sir Robert Peel, the inventor of the Metropolitan Police Force, right? This is actually extremely useful, but not so much on privileges and petitioning, the protection side of it, but actually on the kind of like, it's extremely revealing about the process of petitioning Parliament and the history of it, actually. But Peel was primarily focusing on expenditure and how much it was costing Parliament to, like, you know, print and run the petitioning and so forth. But he also called in witnesses and asked a bit of questions about the history of it. And that's actually the valuable part in this report. When I read it, I made some notes, and there's actually the 1944 report. Mr. Tinker gave good evidence, and that was really good for reminding people that you can actually go to the bar of Parliament and put a claim in without it being endorsed by an MP, which is very important. And there was actually there was something else as well. There was like two main things that were important from the other report. But this one is actually, this report was, right, so the important thing about this report is this. It was done in 1832, right? And it was 2 years before Parliament burned down. So, you know, we don't know if it was an accident or not, or whether it was planned or not. But Robert Peel is very interested in expenditure and how much it's all costing all this, right? I don't think he was a great fan of public petitions, but, you know, it was an intrinsic part of Parliament. The evidence in it is very good. I find it extremely valuable. So I just want to kind of like make a note of what I've learned from it now in case I forget, while it's kind of before like I forget about the points. I've made a little notepad of them all, but just in case like I've written them down and I come back to it later and I've kind of like forgotten anything. So before I look at the notes, I just want to kind of like set out so it was a whole 2 years before Parliament burned down. So whether or not, you know, whether it was, you know, some kind of like Guy Fawkes conspiracy or not, who knows? But it's quite a long time, 2 whole years, although time does fly. So therefore, it's possible that, you know, once you get to 1834, when the incident happens, and then they're rebuilding Parliament, and then it took them quite a long time to rebuild it, quite a number of years, right? And then it's not till 1844, right, when Erskine May writes his first parliamentary practice book, right, setting out all the procedures and rules, right, in a proper book. Although there had been some other sort of books, but not like the official kind of like supposedly one that everyone sort of like took as the main manual, although it isn't law and it's not a standing order. And it's only, the thing with Erskine May is, we got to realise is that the clerks of Parliament, right, sometimes clerks were appointed as triers of petitions, but you have to be appointed as a trier, right? Clerks, the clerks of Parliament have some powers, right? So I think the clerks, they can issue a certificate under the Parliamentary Papers Act. That's a judicial power or quasi-judicial power, right? You know, they're allowed to make decisions on facts. In those, they were allowed to make decisions on certain legal facts, right? But the thing is, they're not elected MPs, so they don't vote in Parliament like MPs, so they don't vote in the chamber, right? And they're not sworn in with the MP's oath. They've got their own clerk's oath for service to the king, right? Now, this is the thing. So the clerk is only the advisor. He isn't a judge, and he's not an elected MP, and he's not the speaker, right? So the clerk only advises because he's supposed to, when he's doing his job properly, know everything and supposedly not meant to be wrong, right? Although, you know, you could argue and prove him wrong, but he's supposed to be the, like, you know, in a court you have a legal advisor, although the clerk in a court is not the legal advisor, but, you know, the legal advisor is the law, supposedly. And in Parliament, the clerk is kind of like meant to be the law. but that doesn't mean that he's a decision maker ultimately. So that means that when a clerk's giving advice, like in Erskine May, it's advisory, right? It's an advisory role. It's not the law. It's not a standing order. And, it is advice, right? Because apparently he's qualified to give it, and you can take it or leave it, right? That is supposedly, how and that's now what I'm going to get into in a minute, how I see it, although I'm not knocking the clerks, but there's a lot. Erskine May covered the whole processes of Parliament, or the main processes of Parliament which people need to know. Now, in his first book, he put the public petitions section in chapter 19, which is significant in his first book because Article 19 is the right to petition in the Bill of Rights. So he paired it. That was a little homage, in my opinion. But that section is quite short. It is only about 8 pages, right? It's about 8 pages long. So he obviously did that for creative purposes, right? Now, you see, at the time, it was his first book. And since 1844 onwards, the book's been added to, edited, changed and adapted. But his first book did acknowledge the right to petition to correspond 19 in the chapter with the 19th article in the Bill of Rights. Now, it's only 8 pages, but when he writes this chapter, it's only a very small part of the whole wider book. Although petitioning had in the past been one of the major, particularly in the 1800s, petitioning was one of there were tens and tens of thousands of petitions coming in. In fact, more than there had ever been in history, right? Because of all the Luddites and the suffrage and all of the other issues, right? And the elections and so forth. So it was actually taking up too much of Parliament's time, but yet it's a very small, short chapter of only 8 pages, right? Now, his rules, that was 1844 when he first wrote his guide to the rules. Now, those guides and rules and procedures are completely different, a totally different impression or picture to what is imparted in this Public Petitions Report in 1832, when Robert Peel takes evidence from several members and staff, right? And that is approximately 12 years before. So they can't have been thinking about it then, it's it's 12 years apart, 12 years between it, right? So whatever Erskine May puts in his book, he probably will have read that report, there's no doubt, right? But he might not have realised the overall importance in the grand scheme of things, right, to what was imparted in that report and what was said, right, and what was public knowledge. But we know that petitioning, they wanted to try and, get rid of it, really, or cut it down. It was taking up a lot of time, and yet it is it's meant to be an important part of Parliament, right, So, and then from 1844 onwards, the book is developed, but the public petitions section has always been relatively small. Also, Erskine May, I think it's Erskine May, they put out a manual of procedure in the public business, which was like a little pocket handbook of procedure in the House of Commons, which MPs could keep in their pocket in case, if things that they needed to do, which wasn't as cumbersome or heavy to carry around as parliamentary practice or the treaty of the usage of Parliament. Now, the thing with the title of the usage of Parliament, it encourages people to make use of Parliament, When they call it parliamentary practice now, the title is not as invocative as it originally was in 1844, that, this is a treatise on the usage, making the use of Parliament, right? Now, I think that Erskine May set up some advice, let's call it advice, right? Erskine May set out some advice in his very first edition, and I don't think that it was true or correct to the true history of petitioning Parliament, let's say that. What he did is, he set out a new standard. It was a new standard that there was, and it's suggestive. He suggests a new standard, in my opinion, right? He's suggesting a new standard, right, for petitions. But it wasn't the law, and it wasn't standing orders or anything else. The law is the 1688 Bill of Rights. If he wanted to put the law in there, he would have said, I mean, he put the chapter 19, but he didn't say, right, now is the public, petition section, and the law for this is it's the right to petition in the Bill of Rights. It doesn't say that in there, right? Now, if Erskine Mayes was only a clerk's advisory offering, right? Because at that point, maybe they talked about, okay, we need to set up a rule book or procedure manual and make it standardised or whatever, but I don't think they ever, we don't know whether they planned or contrived it that it would become the staple of all MPs, and there would be a tradition of clerks editing it and changing it and doing their own version, like Gilbert Campion. In fact, so Gilbert Campion takes part in this report here, right? Gilbert Campion takes part in the 1944 one, with Mr. Tinker, when they say that you can remind us that you can present it at the Bar of Parliament for privileges. Right, anyway, so let's get to this report that we're looking at now. So, 1832, Parliament hasn't burned down, it's still the original Parliament with a painted chamber and everything, right? Now, so let's get some things clear. Robert Peel's asking in this report, he asks, where are the petitions kept? He's told in the Tower, right? So they're not kept in the House of Commons. They're not kept in Parliament. They're kept in the Tower, right? Because that's where all the rules were kept, right? So this is my first thought on that, is this, right? So obviously in the 1800s, this is when they're getting the largest numbers of petitions to have to deal with, and it's costing them a hell of a lot of money to get them all printed and so forth, right? So there will have been a lot of petitions in the building in Parliament. That's true, because if they're getting tens of thousands in, every Parliament, they're going to have, a lot in the building because there's a lot coming in. But they're not all kept there because they're actually kept in the Tower. So they've only got ones that they're currently dealing with until they're dealt with, right? And then they get sent to the Tower. So my query on that is, well, why does everyone say that they all got burned? Everyone says that they all got burned and they're destroyed, right? Well, no, they didn't, because they didn't keep them in the Parliament, they kept them in the Tower. Some of them were in Parliament, the ones that had been sent in and not yet sent to the Tower, but like all of them, like every single one in history, right? Because a lot of them were on the rolls, because they put them, a lot of them either in the rolls or in the journals, right? They get summarised in the journals, occasionally printed in full, right? And sometimes ordered to be printed as well, right? But they would have only have been in Parliament, the ones that had been sent in the post and not yet sent off to be dealt with, and then later put in bundles into the Tower. So it's not like the whole history of England and the House of Commons and the whole of the 1800s has gone up in flames. I don't think so. And the thing is that there's a lot of different periods of the House of Commons petitions. They were from all different periods in time, right? So there are actually a lot of them that must survive, and I've actually seen one of them. So, and then the others are in the rolls, so you can't just get them out and look at them because they're all in with the rolls and so forth. But there were all different types that got sent to different areas and different, whether it was the House of Lords or judicial, or it's kind of complicated because they had triers of petitions, and then they had different ones in different areas. But the House of Commons ones, I don't think that, like, all these original ones from the 1800s got destroyed. Apparently, they didn't. Someone said they stopped keeping them. They stopped keeping the originals until around 1947. They stopped retaining the originals. But the fact to say that they all got burned in the fire is a lie, because they weren't all kept in there. They must have just stopped keeping them, when the ones that did get burned got destroyed. So that's my first point. Am I wrong on that? But that's one thing I want to raise, that the entire House of Commons petitions from, the 1800s and, the 1700s cannot be destroyed because they kept them in the Tower, he said, right? So that's one thing. Now, so So what they don't talk about in this report is they don't talk about the 1285 Statute of Westminster II, which is the right to petition the King through the courts, or the observation of due process of law, 1368, which has the right of the community to petition the King, right? Those are the main two important historic acts. There's meant to be one from 1406 that is mentioned in that P6 form on petitions advice sheet, but I have not found it yet. I've asked them to tell me what it is. I don't know what the 1406 Act is, right? There's that. Then there's the 1512 Stewards Act, but that's about privileges. So they're the ones that they don't really talk about these pre-existing processes, right, of the Statute of Westminster II and the observation of due process of law. They are important in the, after the conquest, the origins of petitioning the King, which I think probably will be in the Ancient Liberties. The Ancient Liberties of London is kind of like meant to be the oldest law since Edward the Confessor. Right. Now, so what are the things that they talk about in this actual report that we've got in front of us, the 1832, which I need to mention, right? In comparison to how it is being run now, the e-petitions committee, and how they're trying to make out that e-petitions is possible because, you can do it. And it, they say that when they wanted to start it, that it was just an extension of the paper one, right? But it's not. They're not letting you. They're saying that there's loads of things that you can't do on e-petitions. You've got to do it in paper, or they don't want you to, right? I don't know how many people do the paper petitions anymore, but there is a lot of revelations in this that are extremely important to challenge the current government and attitude, and even also challenge the Erskine May. These whole guidelines in there, which are only a clerk's advice, right? So, the first thing to raise is this. So, I've got writs without signatures, right? So, in this report, Robert Peel is asking questions and, he's pursuing evidence, and they're talking about, the history of petitioning. So it comes out in this questioning, right, that it turns out that people didn't used to sign petitions. They didn't actually have their signature on them. They were written, it contained their name because you have to know who it's about and who's asking for something, or asking, obviously, if it doesn't, it identifies someone, but it's not what you call conventionally signed, right? So they weren't actually signed, didn't actually have signatures on early on, right? But it was a writ asking for something on their behalf or written by them, right? Obviously, they write their name in it because they need to indicative of who it concerns, right? But it didn't have what you call a signature, so the signature's more for authenticity more than anything, right? Like you get a seal. Now, so it says that they were usually from either an individual or from a community or commonality. Later on in history, they started having the City of London, the Charter of London, boroughs had charters, royal corporations where they had a mayor and aldermen and so forth. Those were more those are what commonalities turned into because you had the jurats and so forth. But the old French word of commonality is meant to be the community. Now, on the Parliament website, if you go onto legislation.gov.uk and look at the Observation of Due Process of Law Act, right, they've got it translated incorrectly because Parliament have, instead of putting the translation from French as petitions from the commonality, the community, right, to the King, which is from, the subjects, it says petitions from Parliament, right? So it's to do with petitions and Parliament to the King, which I think is misleading because, therefore, if you're looking for, where there's the history of, where's an act of law that has, petitioning the King from the people, the subjects, that's it, right? But also through the courts in the Statute of Westminster II, which was a little bit before that, So, Parliament have put an error in the translation on the Observation of Due Process of Law Act if you're looking for your research, right? But a lot of people know that. It's not unknown because some people are commenting on that in other books that I've read, but it's something that I've noted, so that needs to be mentioned, right? Now, but individuals, sometimes the petitions were from individuals, sometimes were from communities. It turns out, though, that the communities did more like a petition with many people who came together, and some individuals were doing things kind of like people do now, like make a political point. They'd write a letter or a message, a little bit like when the Luddites had that General Ludd, and he would go put, leave letters, intimidating letters, but, this fake character, General Ludd, outside, the mill owner's house, or whatever, when they were doing all this, machine breaking and so forth going off. But apparently that's always existed, right? But some of them got prosecuted for, like intimidation or whatever, right? But it clearly was to an employer, it wasn't to the king or parliament, was it, right? But apparently they used to sometimes send some messages like that and put them up in the king's chamber, so they say in this evidence or whatever. So that's quite interesting that individuals, now people will, do, like Tufton Street, if MPs are having a meeting on Tufton Street, you might get Extinction Rebellion doing some kind of stunt, or led by donkeys putting a big banner up outside the Labour Party headquarters, things like that kind of thing. So it's saying that that's always gone on. Individuals have written a notice or petition, a complaint or grievance, and some of them could have been of that nature. But apparently, right, this is really important, under the questioning, it says that there have always been a very strong language, very strong, possibly even aggressive or angry, strong, powerful remonstrations, extremely strong language. So, but they're not allowing that anymore. They're saying that they've never been strong language, or powerful language, or angry language, and it's never, it's not been part of it. But it turns out it has, and it turns out that they have been extremely strong, angry, powerful, vocal representations, right? But yet Erskine May in 1844 says, oh no, it's all, yes sir, no sir, 3 bags full sir, it's all polite, honourable, respectful, temperate, and also, but that's not what they're saying in 1832 when they're taking and giving evidence from MPs. They're saying that it's not. So I don't know where Erskine May's pulled that from in 1844. It's like he's setting a new stand, he's creating something new at that point. And he's not saying that this is the history of Parliament and this is how petitioning is and what it is and how it's always been. No, what he's doing is he's like, he's trying to create or set out new standards. Now, I'm not saying that people abused or, swore at or insulted members of Parliament because, they're right honourable and so forth and the Lords. I've read some of the House of Lords petitions. Obviously, a lot of them are, I have to say, are extremely humble, but then sometimes you'll get one like, it might be a count in an event and giving evidence, and he might say, and the sheriff came over to me with his knife and drew his face close to me and spoke at me in a very threatening manner with a knife held up against my throat, things like that, right? And the House of Lords, one of the members of the House of Lords who was, trying this petition, he was like, he was like, I will not have any petitions that, he was basically making out that it was like, like a threatening kind of language or whatever. But, not to say that a lot of the other petitions don't actually, complain, it's like, must grumble, 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 I'm very, very poor, I've had all my things stolen, and put a lot of detail and facts in there and things like that, and it's history, it's recording history. people's hardships, lives, details, all these things. If they hadn't recorded that, you wouldn't know. It tells you a lot about history. So when you've got these new modern ones, which are effectively like they're wanting it to be an AI program which summarizes it, right? But that's not taking evidence, and Parliament was allowed to summarise it afterwards anyway for their own records, but that does not alter the original claim. It's not saying we don't accept the original claim, and it's not altering the evidence or prayer that you're asking for. Like, when they put it in the journal, they've got poetic license to just, summarise what it's about or what it's generally asking for. That is a separate thing, right, for presentability. Now, when you're starting to people to say that the claim itself, making them change the claim itself, the evidence and statements and excluding facts that you're choosing that you want to try and prove something, or changing what you are asking for, you're getting into the conscience of the person, right? Like in law, the judicial oath in respect to persons, right? Consciences, and what you're actually doing is interfering with the person's own individual soul and spirit and will, which is illegal in the judicial proceedings, right? So this is the thing. So they're managing what they've done they've managed to fleece us and trick us and actually say it's almost like hypnotist. Like, if you went into a shop, right? If you went into a shop and you said, "Oh, I'll have a Twix bar, 3 pizzas and a tin of beans," and then the guy behind the counter is like the clerk, and he goes, "You don't want a tin of beans, Mr. Johnson? You'd much prefer these tomatoes, wouldn't you, Mr. Johnson?" It's like, I was going to get some brown shoes. No, sir, brown shoes wouldn't suit you, sir. You want to get some red shoes, wouldn't you? Wouldn't you prefer a burgundy colour? It's like Savile Row. Suits you, sir. I've come in for a suit, sir. Can you give me some advice on a suit, sir? It's like the clerk, "Oh, suits, I've been dreaming about my perfect tweed suit all week, and I went into Savile Row. Oh, can I have a tweed suit, sir? Oh, no, you don't. Look in the mirror. Tweed's not your colour, sir. You don't want a tweed suit, sir. I much advise you on getting a pinstripe suit. It's Sir Malcolm Jack with a big handlebar moustache, sir. Yes, sir, I'll style you, sir. I'll restyle you, sir, and I'll have you looking all dandy and fresh." Oh, and it comes out with you went in for a tweed suit and pinstripe suit, comes out with like a briefcase and it's like Mr. Ben or something, right? So it's like, it's like you hypnotist, no, you don't want a packet of crisps, cheese and onion, you want salt and vinegar. No, actually, I came in for a packet of crisps. It's like, no, we don't do that flavour. No, well, actually, you much prefer this. So this is persuasion, right? Yeah, they're not, that is beyond their scope, and, they've crossed the line, right? What they're actually doing is wrong. It is completely wrong and criminal. It's an abusive process, right? In the judicial system, it is an abuse of process, and it is that is the classical and perversion of the course of justice, right? It is the perversion. They're perverting, right, the course of justice, because they're actually saying, no, maybe you don't want justice, right? Mr. Smith owes me £5. I'm going to need to sue him. No, sir, don't sue him, sir. Don't sue him, sir. You don't want to sue Mr. Smith, do you, sir? You're feeling sleepy. No, sir, you don't want to sue Mr. Smith, do you? So you don't want to prosecute, you don't want to prosecute Rees-Mogg for election offences. Well, the chance would be a fine thing if I had £5,000 deposit. I might give it a try if I knew what the election law was, You don't want to prosecute Reform UK, Nigel Farage, So it's kind of this like, it's absolutely scandalous what's happening now. It is scandalous, absolutely criminal and scandalous. And the fact that they're even like rejecting them all and officially saying that this is how it's rejected, right? Well, yeah, it's still on the system, still on the record of England, but it's rejected. You know, accept this, right? You can't do that, right? You know, it's just they had these people called triers of petitions, like bishops and so forth, and you could get a judicial resolution, but they sent it to where was best appropriate, right? You know, it's them who sent it off to where was best appropriate, whether it needed a judicial resolution or not, right? But when you get into all that, you know, it's to do with how Parliament was one chamber and then two chambers and then and so forth. But right, so yeah, I mean, they're now. Where the there's a joke going on, right? The triers of petitions, but they're the people who make the judgments on it and decisions. But well, it's like, but yeah, but we don't really have any people who make judgments or decisions now. Only this like team of 4 people, right? You know, Sean Harris or whatever, or you know, Gareth Price or whatever, right? But they're not elected MPs and they don't have any judicial powers. They're not even clerks of Parliament, right? And they're on. You know, they're not on like tuppence like clerks used to like, you know, check signatures on, 10,000 petitions and get 5p. Now they're like, you know, rejecting all our petitions more than that get submitted, and they're getting paid an absolute fortune, right? And we are now the triers. But the word trier doesn't mean that you're going to be a judge, right? Because then you'd have judicial power. No. Trier, it's not like trying the petition is actually making a decision or judicial action on it, you know, to get the redress or resolution. Now, trying the petition is actually just trying to get it accepted. But yet, there are no rules for accepting it, you know. It's not supposed to be, right? It's meant to be fitting wherever is best fit, or if they don't know where best fit, they want to find out, right? So, we've been transformed into people who try to submit petitions, not actually the people who tried them were trying, actually judging them, right? Which is quite, I think this is scandalous. So, right, let's go back to individuals or communities, right? So, individuals did do petitions, or communities, and the communities were where it was usually a large number of people, and they were usually asking for some kind of public, they might want the laws changed on taxation or farming or whatever, but the individuals, it's mainly either usually judicial or, they got some, obviously, personal misfortune or grievance, right? Now, the thing is, they're saying that no one really very few people knew how to learn to write. So even if it was an individual, they might not have written their own petition. They might have got the local clerk who might serve the local magistrate or someone like that to write for them, right? Or a lawyer or a solicitor or someone, right? Or usually maybe even a local priest or someone at the church to write for the individual, okay? Now, as for when it was the communities and when it was more people, so they did used to, large numbers of people gather together, come together in a big group and get the clerk to write the petition out for them. So this is all to do with forming remonstrations and demonstrations in public, right? Because they would all come out together with a complaint and then go down and they say, right, we want it put down in writing and, say it's from us, the commonality. But they weren't necessarily all named because they didn't sign them back then, right? But it set out that, the commonality had this complaint or grievance. Now, this is the thing, right? So, the large groups of people couldn't write, and the petitions didn't have the signatures on them, just the request and who and where it was from. Now, they petitioned the king sometimes, right? Not just, it was to start with, it's one parliament, right? It's one parliament, and then they get sent off to these triers if it's judicial. But they've also got those petitions going through the Bill of Exemption if they petition the king as well, through the Statute of Westminster II, right? But you've also got the observance of due process of law, which is petitioned to the king. Now, there are different opinions, but in the Gwyneth Dodd book, they say that not many people, fewer people petition the king because, like, apparently he wasn't that competent at the law, or didn't know that much about the law or the running of the country, actually. But he was the only person who could grant things of grace, like pardons and things like that, or when it come to lands. But usually it was the Parliament and the Assembly, right? But then there's still, if it's judicial, it goes to these triers. But it did gradually change. But there's the evidence that I want to mention or raise is this, right? They said that if they did petition the king, right, he sometimes might give this particular reply, which is like, if the community if the king had some lands, like, what he had for deer or hunting, right, and then the community said, can we, use or have some of this land, right? The community want to have or use some of this land. Can we have a legal right to it or whatever? And the king might reply and say, no, the community don't want that land, right? The community aren't interested in having that land. They don't, right? And that was apparently his way of disposing of the petition or getting rid of the matter. Because in that book, he actually says that, this is important, that apparently Parliament have to, if someone makes a complaint or grievance or petition to Parliament, apparently they've got to deal with it, or they've got to actually resolve it. That's what Parliaments are called for. So that's another thing. There's an actual legal obligation to resolve complaints. So that means when we're doing it to e-petitions, really, they've actually got a legal obligation to sort the complaints out, not reject them, and definitely not change what you're asking for, and definitely not, exclude some evidence that is really strongly going to prove your facts, right? So Parliament's meant to be there to resolve problems, right? Now, so if a community came together and got a clerk to write the petition down on paper for them, said, like, the commonality of, I don't know, like, Bruce and Edmonds or something, right, want to use some of the king's lands for hunting or whatever, for example, right? And then the king comes back and says, no, the community don't want to use my land, right? Well, how can you, well, we do, right? So this is actually where I think the signatures would come in, because, but they didn't used to have the signatures on, right? So he said, well, actually, no, the community do want that, and we'll prove it by collecting their signatures. So we get all the signatures on there, and they all sign it. Well, look, Your Majesty, you said that we said the community want to, use it for pheasants, pheasant hunting or whatever. Your land, a bit of their land, if you don't mind, please. And then you said, oh, no, actually, that's not what the community want, I say, well, actually, no, because, look, we just collected all the signatures of the community. They've all signed it, so they clearly do, Your Majesty. And it's like, oh, so you can't say, no, the community don't want that because they just signed it and said that they did, right? So it seems to me that's the kind of thing when all the signatures come in to because what it does, it proves that they do want what they're asking for, right? And I think this is the ironic thing now with e-petitions, whereas, you get 5 signatures, submit it, but then it doesn't go live and they won't let you collect any more or share it to anyone to let anyone know the evidence or see the facts in order to prove compelling reason why to support it, and then very much weight of signatures. It's like Keir Starmer now, right? Hey, look, Keir, the public want a general election. Look, there's 3 million people signed, right? It's like Keir Starmer's like, no, the people don't want a new general election. They just voted for me, for Labour. Well, actually, no, they do. they can't stand Labour anymore and they want them out. And we'll collect all the signatures to prove it. Look, 3 million. Well, that's not many. There's, 60-odd million people in this country. It's not very many. Well, actually it is. It's enough to, we're getting close to 10% in each area. It's enough to have a recall petition on each MP. That's surely significant, So that's a little bit like the similar kind of situation. So then what you'd have to do is, collect, 5 million or, 10 million signatures, or even, 25 million signatures, and say, look, Keir Starmer, half the country, more people than who voted for Labour or whatever. So it's a little bit like that, sort of thing. So that's where the signatures come in, because the signatures prove that it's what people want. So that's another thing. Oh, yeah. So, how do they, when you ask for something, how do they grant it or do it? Well, this is the thing. So, what they're saying in this 1832 report, what I found very interesting and significant, is that there were various different ways these petitions got a resolution or got a resolution or remedy, redress. And sometimes Parliament could just do it through normal process and procedure, but other times they had to enact law, right? Because making a law was the only way to do it. And that making the law was actually a form of a redress or a remedy because there wasn't any other. And you see, but these are from individuals or communities. So like they had to make a law to resolve the problem that the community have got, or an individual even, right? They might not be able to get a remedy through like a justice or the courts, or, Parliament find a solution, so they actually make an act for it, right? Now, so this is eventually where public bills come in, private acts, private bills. But when there weren't all these corporations, when there was a City of London corporation, maybe in, some boroughs, Edinburgh, Bergs, and certain cities, right? Before all these, the city corporations started petitioning for things like, Manchester and London wanting this and wanting that, and, shipping companies and this and that. It was communities and individuals. So actually petitioning for a law to solve your problem originates from the community or people. And also you got these guilds of guilds of craftsmen as well, because they didn't have big companies like, Amazon and YouTube and so forth, and everyone working for, cornflake factory or whatever, or biscuit factory. It was like everyone was skilled and, were skilled craftspeople, but they came together in a guild, right? So actually, now it's only big companies who are wanting private laws put through. Big companies, paying for these parliamentary agents to, draft up new legislation and sponsor it and help them get through Parliament. And it's not something that we do, the members of the public, right? You go on e-petitions and say, I've got a problem. So, sorry, we'll put you a new law through, Mr. Smith. Oh, just for me. You're going to make a new law just for me, right? But apparently, we'll have to justify making an entire new, putting an act through Parliament, maybe getting, 20 signatures or maybe 3 million, or something. I don't know how many. You see, these big companies don't get loads and loads of signatures. All they do is, lay the bill there, and, you might have 4 people support it or something like that. I don't know, because I haven't got around to looking at private bills and how they got put through yet. I've had a little bit of a look at it. I've got a general idea, there's certain forms to fill in and so forth, but it's all big corporate sponsorship. But all the money comes in paying someone to draft it and paying someone for the expertise and then paying someone to the legal processes for you, not just like, not cobbling it together on e-petitions and then, putting it through, make me a new act of law, But that's what it's actually meant to be, It's meant to be, but they've made it into like a whole... It's almost kind of like, getting first class on a plane, no one can even afford to go first class on a plane now unless you're like Bill Gates or whatever, right? And that's a funny name, Bill Gates. It's almost like a pun, Bill Gates. So, but they've separated it now. Actually, you just, what they're saying in this 1832 evidence, what Robert Peel and the MPs that he questions are saying, and this is a parliamentary document, they're trying to say that people just petition Parliament for whatever they wanted, and then Parliament would just like, how are we going to sort this out? And then say, we might have to make a new act of law, right? And that's it. But after Erskine May, there was like, petitions about private laws or private bills are a different thing. They're a different thing. You got to do the proper forms and the proper processes, and it's all this like business class or whatever, and it's not the type of thing that you took in the Speaker's petition bag or whatever, and the Parliament sort out. It's a different thing, right? Almost like a different class of thing, but it's actually not. But they made it into a different class of thing, right? They transformed it into that, but it's not, through, the whole history of Parliament, it isn't that, right? But they've made that kind of like, only for people who can afford to throw, £20 million at Alex Dilliston or whatever. So, or some parliamentary agent, to knock you up a bit of legislation, and Keir Starmer comes down the corridor with it written on a doily or something. Hey, look, We've been busy today. This is my bit of paper. Starmer's walking down the hall. Slowly walking down the hall, faster than a cannonball. I've got a bit of paper in my hand. This is Keir Starmer. He's got a piece of paper in his hand. A4, is that Keir, or is A5? He's got something very, very important written on this piece of paper. It's the recipe for Mars bars. No, it's a very, 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 very important piece of paper, this. And look, I'm very proud of it, I've just come out of the cabinet meeting with this very important piece of paper. There's magic words written on it. This is going, when we get this put through to the Public Order Act 2023 or whatever, or the Online Safety Act, and all your pawns are going to be blurred out, Won't that be a nice little trick you weren't expecting to creep up behind you or whatever, right? This is a really important piece of paper, like an e-petition where you can fit like 7 words in it. You need to put me in your act of law through. No, we can't do that now anymore, because now you've got to, that's in, that's in bowling lane number 1, not in bowling lane number 5, it has to be submitted. It's all different. Since when? Since Erskine May put out this new book. It's almost like the Reformation or something. So that's actually important, because basically all our grievances and complaints could have been resolved with a bill, if that was the way to do it. It didn't have to be like, it's Bill Gates, he's got £10 million, he can throw it at a parliamentary agent, and they'll get all these sponsors and, put some legislation through Parliament. And, you might be lucky to get, some MPs back in it, take them out to dinner, buy them some champagne, take them out to the Hilton, we're lobbying now, I hope you aren't bribing them. No, we wouldn't be doing that, would we? It's like the Speaker's Conference. Look, now the Speaker's entertaining some foreign diplomats. Hey, are those the foreign diplomats that are doing G40 cities with Sadiq Khan, by any chance, that you're entertaining there in the Speaker's chamber? Hey, look, where are these new law ideas coming from? Sadiq Khan's foreign embassy, They were just complaining about all the foreign influence that's going on Michael Westwood's petition. There was all those foreign influence, Well, it's just a bit of sharing, helping spread the word. So, there's that kind of aspect to it as well. Signatures for evidence to prove something, because, obviously governments say that, people don't want there to be a general election. Oh, yes, they do. Oh, no, you don't. Oh, yes, we do. Oh, no, you don't. Yes, here's the evidence. But individuals have always submitted petitions as well. But they didn't necessarily need to have this. If it's just from one person and they writ it and it's about them, why would it be from someone else? But this is the thing. I suppose you sometimes would get people pretending to be someone else, which could have been quite mischievous. So maybe that's why they started putting the seals on them. But, we haven't seen a lot of the House of Commons ones, right? They said that they'd all burned, but I know there's definitely some on the rolls, some of the really, really older ones. But this is the thing. I've seen one from Edward Vowdry, but I haven't seen the original piece of paper. I would like to see some of them. Obviously, if they got 20 after 1661, well, that's the thing. They were saying there was a lot of mischiefs, weren't they? They were saying, so that might have been some of the mischiefs that were going on. Like people pretending to be other people or whatever, not just tumultuous assemblies. And that might be why after 1661, if there was over 20 people. But then again, if it was under 20 people, they didn't. You didn't need consent, but. If you get the judge's seal on it, that's some kind of authenticity to it as well. So, most people couldn't write. So groups could come together and usually get someone who could write to do it, preferably a clerk. Now, if you've gone to the local magistrate or to the local clerk and you're petitioning Parliament, it's not the local court, or if you couldn't get a resolution in the local court, and you get the clerk to write it, and it's a big group of people, then you definitely know that you're petitioning Parliament, and you've got this privileged process thing, right? Which is currently the courts are not recognising that you are petitioning Parliament at all. They don't think that it's a thing, right? So that's one thing back then. So this is to do with, are public remonstrations, public assemblies, petitioning. Well, if you're making a request, but usually it has to be put down in writing, which is why you get the statute of the observation of due process of law. Because sometimes people were like arresting people or taking people before the king or to the king or to parliament, just like grabbing them and arresting them, and it was causing some problems under the parliamentary jurisdiction. And that's why they said you've got to have an original writ first, send the actual evidence in the writ. So observation of due process of law is really important in that, to get it in writing. And the tumultuous Petitioning Act suggests that the Tumultuous Petitioning Act suggests that they could have had other consents, like by word of mouth or whatever. Now, the thing is, if they weren't actually signing them or putting their signature on, and the clerk wrote it out for them, and they didn't actually sign it each, you wouldn't actually have signatures on there. So how would you know they consented to it? Well, the commonality did, if he wrote their names on there but they didn't sign it. That's almost kind of like, they gave some sort of verbal contractual agreement and the clerk wrote it down on paper, but they didn't necessarily all have to sign it, each one with their own hand, right? So that's tied into the observation of due process of law Act for petitioning Parliament, anyway, in the King. But obviously now we've got the whole court procedure and so forth and so forth and so forth, right? And we don't have the Tumultuous Petitioning Act anymore. So this is the thing, is it a matter of record if people come together and consensually verbally agree to something? According to the observation of due process of law, it does have to be made into a matter of a record or some form of writ at some point. Now, does that qualify if Extinction Rebellion put on their website, like, these are our demands, to the government? Is that a writ? Like, is it addressed? Is it addressed to Parliament? Are they asking Parliament? Does it have to be sent in? Are they going to send it in when they finish collecting signatures? Like, this is the thing. So these are some interesting points to consider. Trial by bishops or knights appointed may relate to an earlier period. Well, I've just been reading about that. So you got these trials of petitions. The bishops were involved in judicial processes, right? That's there's a book that Robert Peel refers to, which I've just actually got it for free on PDF, downloaded it, which is quite informative about these trials of petitions. And then that Gwyneth Dodd book, which I've also bought that as well. I've just read that section on it. And that's to do with the earlier periods. Oh, yeah, what they say in this 1832 paper, which Robert Peel, which is the subject of this talk, is that he's asking about it. Robert Peel wants to know about it, so they're discussing it. And he's like, well, apparently the Civil War kind of disrupted all that trials of petitions because they had a lot of them heard up in they had this great northern... they had them like heard in York and Newcastle and Hull and places like that, but under the parliamentary jurisdiction, right? And apparently when there was the Civil War on with Cromwell, it disrupted it all, and then after they'd finished, they never bothered doing it back again. So when you've got like, I suppose from around the time of John Pym onwards, because John Pym's getting things put through Parliament, people to be released from prison and so forth from petitions, right? Judicial ones. So, like, from, Cromwell's protectorship onwards, and then this is when you get the 1688 Bill of Rights right to petition. At that point, they don't have those triers, as to say, you are actually petitioning Parliament, the House of Commons or Lords. Another thing, it says that the Privy Council was like, well, are people petitioning the King and Council or the King? Well, sometimes either or. But it was saying that in the early parliaments, the Privy Council was considered and regarded as one of the committees of Parliament. It was regarded and considered as like a small committee, a part of Parliament. That's what they're giving in this evidence. So they would suggest that the Privy Council is almost like, the Privileges Committee or the Committee of Forfeiture or, the Petitions Committee or Ways and Means or whatever. It was just like one of the many committees, so therefore things could have been referred to it, to be tried or for judgment, but they don't seem to be doing that now with e-petitions for sure. You're not allowed to do that, you're not allowed to do that, you're not allowed to do that, right? Well, why not? It's a legal right, we got the Supreme Court, yes, but we have to pay. You've taken away everything that's free, including, election petitions. You got to pay £5,000 up front, and if you lose, you don't get it back, See, what happened to what we're paying our taxes for? Services, we got the Ombudsman to sort it out. No. The Ombudsman's not going to sort anything out. The Ombudsman is just going to tell us that we're wrong. No, we're going to get it, the evidence on the petition site, on the record, for history. I'm going to share it. Going to get everyone to know what the evidence is, and if you still won't act, when everyone knows that Nigel Farage cheated in talking pints, he scammed the election rules, he's a cheat. His whole party's cheating, right? Because he used a private company to boost his popularity criminally to win an election into Parliament, right? And, if people are so drunk on reform because they hate Labour so much and everyone's dazed and confused with what's going on, we need to inform them about that. And, if they won't act on the evidence, then we need to compel them to act with, a very large weight of signatures, like Michael Westwood, 3 million signatures. Nigel Farage cheated at the election, and he used talking pints to boost his popularity and invited Priti Patel on and loads of other guests to convince everyone that he was, he's safe to put the vote on, and he cheated. He's a cheat. Right? And that's how he got elected into Parliament. And the Electoral Commission are wrong. They're so wrong about the law. They don't know the law. They're so wrong and brainwashed by Parliament. They're not even... The Electoral Commission are new. They haven't even been around that long, right? Just like, Erskine May is actually so wrong about, how temperate a petition can be and, what word in the language it can be. According to George Strickland, right? According to George Strickland in this report, petitions have always been extremely strong language, very, 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 very strong wording. Very explicit, although you're not allowed to, maybe we're not allowed to insult MPs, but now they're trying to say that you're not allowed to accuse an MP of any wrongdoing or doing anything wrong. No, actually, no, you are. Because where else are we going to hold them to account if it can't be decided anywhere out of Parliament, right? It's have to be decided in Parliament. That's why I'm trying to get this petition in. Because it's how we remove evil ministers. It's how we point out malpractices in government. As all of the Lord Mayors have stated in their petitions, the Constitution's been violated. Straight from the horse's mouth, Lord Mayors of London, complaining about the Constitution being violated, right? So, we're being scammed. So this is the thing now currently with e-petitions and Jacob Rees-Mogg, like, oh yes, you've got privileged rights, but I'm afraid we're going to have to take those away from you because we can't have you putting libelous, scandalous petitions out, particularly if they're correct, if they're true, like, Mogg, you cheat, you election cheat, you cheat. With your own GB News programme on, £80,000 a day or whatever, that's how much we should fine him for cheating, making himself into a celebrity, It's all about fame now. How famous can you be? How much influence have you got on the people? This is the thing. But I lost the election in South West Somerset. Yes, you lost it. Everyone knew that you were a cheat if they didn't vote for you, right? This is the thing. It affected the outcome of the election. So this is the thing. So we are really getting scammed by these, people newspaper gurus. That's another thing, Jacob Rees-Mogg, the son of the newspaper empire baron who drives around in a chauffeur-driven car. Hey, Mogg, do you know anything about the newspapers charging petitioners VAT on their adverts, so we can't get them into the newspaper and have an effect and influence on the very upmarket Savile Row clientele who buy the, Daily Mail or whatever, and, Boris Johnson's little influential newspaper column in there as well. Us rabble in there. Not that any of us rabble can afford it after they've, put the prices up, 5 times more than it should be, and then charge us tax on top of it, illegally, criminally, right? All these newspapers are criminal because they're criminally extorting tax from us when we're exempt and don't have to pay it. And, we're not going to claim it back later without a recommendation from the king, apparently. But, if you don't charge us it in the first place, then you don't take it off us. So, maybe Rees-Mogg can pay everyone their tax money back out of his GB News wages, seeing that they're all illegal. So, Northern Circuit, we've mentioned that. Strong language, mentioned that. Individuals... creative expression, while groups, so individual persons did have creative ways of delivering or presenting petitions even back then. So they were suggesting sometimes people did, or sometimes some of the groups or like commonalities, like because they were like larger groups of bodies of people, they might actually pay a lawyer to represent them. Well, that's kind of literally now what the big businesses are doing, mainly because they've got the money, because they're a big business, Hey, we'll throw like £10 million at Alex Tilliston and she can cobble us together an act of law, to make tampons, tampon tax, a new taxation scheme for maybe women. Maybe all women's products should be taxed, at half the value to men's, just because, they should. Maybe. I don't know. So this is the thing. Many people would come together and then use their money to pay a lawyer to get them to get an act of law made or changed. But now people don't come together. They come together in e-petitions like Michael Westwood, but they're not getting a resolution because they're being restricted in what writing they can put, and they're actually being rejected. You can't ask for this, 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 right? Why is Michael Westwood getting his 3 million people, and they all saying, right, we want the law changing, to make it illegal for MPs to, reject petitions or something like that, right? Because, they're trying to prevent us really from doing powerful group litigation where you get facts on paper added to the bonus of many weights of people, right? Because in those local election petitions, they say you can only have 4 people sign it, right? Well, the election petition is £5,000. Let's use the election petition example, right? So, people in a town are annoyed because, Rees-Mogg cheated in the election, let's say, for example, right? So they all petition Parliament, and complain. And then, they have someone look at it in Parliament, right? Oh, no, we can't do that, right? We'll have to have it seen locally. And, okay, we'll have it in a court, right? Well, it's in a local area. You're only allowed 4 people to sign it, right? And it's the weight of the evidence, really, that's important. Can you prove this by facts? Yes, here are the facts. He cheated, right? Right, well, that's fair enough. But now it's like, have you got £5,000 deposit, though? Oh, well, I might have to go get Michael Westwood to give me with his, split it between 3 million people. Well, you're only allowed 4 people on this petition, Well, it's like, well, if, 3 million, we've got 3 million witnesses, though, who say that he's a dirty cheat. This is the thing. Well, no, they don't, because now he's peddling, he's influencing them. He's on TV saying, I'm not a cheat. And he's telling them how to vote and what they should believe in and what they should do and, how they should live their lives and what politics they should be voting for. He's a very, very, very influential person, a demagogue like Tony Blair, and he says that he's not a criminal and, that, you're wrong to do that. And you shouldn't be, voting for Reform UK. You should vote Conservative. This is the thing. So, It's like, are you influencing people in their votes? So that's that. I mean, it's you get the evidence down, written down, very strong, compelling evidence, and some people were paying lawyers to make them do a very strong claim, and then it's a commonality, a whole town, and you might even get a new law made or changed, right? But now people aren't coming together. And you can't get a lawyer to put it down because, even if you paid a lawyer on e-petitions, you can't write that many words. Although I think you can put a link, right? You can put a link, but if you put any strong evidence for anything on there, they're likely going to reject it. It's all ways and means, isn't it? So private bills aren't really for the community now, because if they were, people would be doing it, but they don't sort of, where's the simple process bills petition website, where you just cobble it together with, fill it in. None of this, paying a parliamentary agent nonsense, just write, draft act of law. Where's the draft act of law app, Hey, look, create your own legislation. Insert the arms of England. What do you want this act to be called? And what are the main provisions? And what is it going to relate to? Look, design a bill. Hey, look, it's the Bill Gates app. Bill Gates, design some law, and then get 4 people to sponsor it, or did you do this yourself, or did you pay someone to knock it up for you, right? And did you get AI to do it? I used AI and it evaluated other acts of law and how it's worded, and I asked it what I wanted to legislate for, and it just worked out for me, and that was free, the free government AI legislation app. And, now I'll collect signatures to sponsor this bill. Hey, look, I've got 3 million signatures, sponsoring this bill, make the name Care illegal in England. Make the name Care unlawful in England. No one's allowed to be called Care in England. Look, 3 million people have signed it. Let's get this put through. Let's get this bill put through, It doesn't cost me anything. All this sponsorship is get it filled in. Just get it filled in. Get a bill drafted. Now the House of Lords have come back and said, we don't like these 2 parts. Could you please, change them or make some amendments for us, please? We don't like it. Well, that's funny because someone's actually flagged this act now. Someone's flagged it. Someone's flagged the act. It says, this act is illegal and against the Constitution of England, because it contravenes Magna Carta, or something like that. It's been flagged. This bill's been flagged. Never mind being rejected. The Lords have come back with amendments. Someone's flagged it. It's incompatible with convention rights. This is the thing. I like to see the next government we've got knock that together, and we'll see how the parliamentary agents do with that when everybody's using AI. Cobble me an act of law together and get people to sign that. Smoke me a kipper over bat for breakfast. No particular language restrictions, but legitimate to the true grievances. Well, that's the thing. So yeah, they weren't. They put in this 1832 report, they've effectively laid out all of the relevant resolutions of the House. But the thing is, Erskine May is selling it as these are all the rules of Parliament built up over time, and this is what the law is of Parliament, right? All the standing orders and resolutions is what they are. But according to this 1832 report of Robert Peel and these MPs giving evidence, they're saying those were only resolutions that were adopted at a particular time for a particular reason, because they might have been busy or to get through a certain problem, and then at later dates they had different ones instead, not as well, but instead, right? So they're not actually, they're just different ones that have been at different times. That's what they're saying, right? And particularly that one that says about, how fit they are to receive the petitions. It means where do they fit in, usually. And they're definitely not all rejected on, strong language. Apparently, they've all got strong language. Apparently, obviously not want to be insulting, but you're allowed to accuse. This is the thing: the ones that are rejected, which are slanderous or scandalous, are because they're fabricated or not true, right? If there has been malpractice and if someone's done something wrong, right, you're allowed to put it down. But this is the thing. This is all the ombudsman complaints are and things like that. But apparently now they've got these modern things that it's almost, they don't, e-petitions is there to use it, right? It's there not only to put evidence down and complain to the government, but also to collect compelling evidence that the public want it sorted out, which you can't really do with the ombudsman because it's just you and your complaint. This is the thing, and you don't have anyone helping you financially, right? When you've got group litigation, you suddenly got a lot of money and you can pay a lawyer to help you, right? Which these commonalities did, right? Which no one comes together for that, not in parliamentary processes. They don't. Well, what they do instead is they just turn up at London in a massive mob and hold signs and say, get Starmer out, or whatever, right? They don't all come together in London, pay a lawyer like Alex Dillistone to, get a bill saying, get Starmer out now, make the name Keir illegal, and put it through Parliament, and then get 3 million people to sign it, right? And say, right, it's not me kipper on my back for breakfast, right? No, they don't do that. So that we're not getting the effect. You're not getting the power and the drive and the force behind these big groups of people because they're using the money to, throwing money at people, getting banners and signs, and all turn up at the beach in Dover and all whatever. And then we're not even getting the send the police to block them. Oh, just a minute. We're getting. Get the where's the clerk? Where's the clerk? A Parliament gave it down on paper. Outside Parliament, call up the clerk because it's written down. Getting a very, very large group of people outside Parliament want to ban the name Keir. They haven't signed this piece of paper, but I can attest that this is a writ of record. And if any of them get arrested, then they'll be inside to the bar to complain grievance of privilege, and they want a certificate from the Speaker, right? Is that how it works? This is the thing. Sarah Davies, get Sarah Davies out here. There's a very, very large group of people outside Parliament saying they want to make the name Keir illegal. They want it written down on paper, and then if any of them get arrested, they would be coming in for another piece of paper saying that they can unarrest them. This is the thing, right? Right, so rejected petitions. So this Strickland, George Strickland, so Robert Peel questions him, right? He's talking about, how often does he get petitions rejected? He says that he doesn't get them rejected, or that he claims that he hasn't had any rejected. Now, that is because he says that he's always managed to argue them being eligible to be accepted, right? So he's used his own skill, guile, it's almost like in the oath of a police officer. I will use all my skill, I will use all my skill to find Madeleine McCann, all my skill and knowledge, and talent, and my shiny badge that I got, and my sergeant stripes. I'll use all that skill, to argue this petition into Parliament because, Sean Harris and, Gareth Price are trying to say that we can't run that, Well, I haven't had one rejected yet. Well, the clerk's advising me. This is the thing. And the clerk, right, so the clerk advises on the petition, right, what is generally acceptable or not, or what is something Parliament can or cannot do, right? Well, George Strickland has told that clerk, said, no, this is acceptable, I'm sorry, the petition's not acceptable, we cannot make Keir's name illegal. No, it's perfectly acceptable to make a name illegal, it might be offensive to some people, This is a thing, like praying outside an abortion clinic. That offends some people, there's always someone who gets offended by something, possibly even the name Keir. right? So we should make it illegal. Oh, well, you talked me into it. That's what you see. There's always an argument or debate to be won around here before the petition gets rejected and I have to collect the 5 signatures over and over again or rephrase or reword it, as this is very compelling, strong evidence we've got here. So Strickland never lost an argument with a clerk over a petition or with his fellow MPs or the Speaker. Apparently he always managed to persuade them that it was perfectly admissible. Wouldn't chance be a fine thing. Now the petitions team cannot engage with anyone. They may not enter dialogue or engagement about the submissibility or admissibility of a petition. Wow, a privilege reserved only to George Strickland. Or me, if I'm going in for a privileges claim, because apparently, according to Mr. Tinker, a member of the public can go in and they don't need an MP to present it. So, I can argue my own petition in with the Speaker that it's admissible or acceptable, right? Not even need Peter Fortune or David Simmons or, any other number of MPs that there are to argue it in for me. Because, I can argue it for myself, right? You can't do that on e-petitions, and there's no MP is going to be there for MP entrusted. Entrust your petition with your elected MP or local representative who's out there to fight and vouch for the people, right? Through the punches, get in there, get in the chamber, get in the thick of it, fighting for the ULEZ, or whatever it is, fighting for the people. Like Theresa Villiers is for, stop ULEZ, throwing the punches. No, you don't get any chances like that, You just fill in the electronic form and submit it, then say, sorry, not allowed. Well, actually, I wanted to raise a point on that, and well, it is allowed. I was just going to tell you, well, no, you should have put that in, you should have put the argument in the petition why it's allowed. Well, actually, I didn't have room for it because you're restricting how many words I can put in there. Well, you better look next time. Well, you better have already collected the signatures. Well, you have to change it and try again. But I want to argue the points on why the first one is submissible, like Mr. Strickland did with the clerk. Well, no, we don't allow that anymore because then you might win and then you might publish it. And clearly, we don't want you to. I don't want you to win the argument. That's why Jacob Rees-Mogg said, well, this might be privilege, but we need to take those privileges away because you can't be using those now, can you? You might make good use of them. Like, possibly even, give evidence that Rees-Mogg is a criminal. That's slanderous to him. Well, but he is. That's the fact. It's the truth. He cheated in that election on GB News. They funded him while he was running for election. Made him more popular. This is the thing, it says in the representation of the people, well, we can't hear election petitions now. You'll have to get them heard in the local area. It's £5,000 deposit. Oh, I don't have £5,000. I just have the evidence that he cheated and, wouldn't like to get this up on there. I might get, 10,000 signatures and we might get an opinion response from the government. No, it's, sorry, you need the pound notes for that. It's all money now. It's the upfront hard cash. Well, I don't have any hard cash, but Mogg's not short of hard cash because he's presenting GB News and getting paid £80,000 a day or something, £80,000 a day, I could, it's £80,000 a day. That's £75,000 extra than I need to do the election petition to prove that he's a criminal. Wouldn't that chance be a fine thing? We were getting blocked, obstructed, scammed, persuaded, you name it, they're doing it. What scam aren't they doing? What lie aren't they telling at the moment? Scandalous, absolutely disgustingly scandalous of the common rats, the common mice, the ferrets, the feral populace who are supposedly, that's what the courts are there for. We were here to protect you and look after you because, we don't want you to be harmed or upset, do you? No. You might see someone flashing their breasts on YouTube. We can't have you seen that. We'll have to blur them out. But, what happens if your 10 years worth of YouTube work gets taken down? Well, don't be too upset. It's not too much of an injury, is it? After all, you're a naughty boy. You showed a pair of breasts. But there are already breastfeeding videos on there with women with their breasts out, with their babies sucking their teat on YouTube. It's allowed. Yes, but there's nothing sexual in that, is there? Well, I didn't, mean there to be anything sexual when Russell Brand was on there with his, cardigan. But, apparently women are getting a sexual reaction from it, This is the thing. Well, it's, don't we have to do more harm than good, taking down these, channels that you've had up for 10 years with all your work on there and all your videos and all your evidence in legal proceedings, well, actually, yes, you completely and totally stole the last 10 years of my life and ruined it. Right? You've caused 1,000 times more injury and damage to me than I caused to anyone. Because when I uploaded that video, it was against the policy, nobody saw it because I uploaded it privately. So how have I harmed anyone? Well, this is the thing, we're punishing you for tinkering around, taps and tinkles, and, we're just going to slap you in the face for it. It's like, oh, you tickled me with a feather duster, so I'm going to have to headbutt you, Oh, you tickled the screen. You tickled the screen with a fancy, so now we're going to have to devastate your whole life as punishment. And we're not the bad people. No, we aren't the bad guys. This is justice, you spit on someone and then we'll lay you in the road and run you over a steamroller. That's justice, It's like we always do more harm than good. We're meant to be here we're protecting people. We're protecting the citizens, protecting the community from harm, Are you protecting the community from harm? Look, a leaf fell on my head, but now the punishment is from Neil Mohan. You'll have to lay down on the road and have a steamroller run over you. This is the thing. This is the justice of YouTube. The justice of YouTube. Make sure you do 1,000,000 times more harm to people than they're actually doing to anyone, or not any harm at all. This is the new. God knows what it is, megalomania, it's America, freedom of speech. No, America hasn't had freedom of speech since 1996 because everyone talks on the internet now and there isn't freedom of speech because apparently they can take down what they want. Apparently it's not constitutionally protected anymore. They can remove it. So there isn't really freedom of speech. She's like, well, then you can say it, but, after you've said it, we'll have to take it down. Committee to understand using powers. Oh, yeah. So that's like... the powers of the Petitions Committee are meant to be to call for summoned persons, documents, or papers, right? In order so they can understand the petition. But the Petitions Committee can't actually themselves investigate the petition. It has to be referred to someone who can, a committee or, somewhere that does deal with it, right? But supposedly not to government departments unless by order of the House because they're not elected and they don't have the judicial power of the High Court of Parliament. But Parliament can make an order for it to be sent there, for the resolution, but not directly from the Petitions Committee, and not for if it's submissible or not. Government departments haven't been elected and they're not judges, and they, you might be opposing the government department or something like that, right? They don't. Government departments don't make judicial decisions on a petition's submissibility or give advice on it, right? That's for sure. And the committee is meant to use those powers it's given in order to understand the petition, right? So that means that if they don't understand what you've written, they can call you in and summon you in to tell them, right? But Genius, Mog, and the committee, the management have said, hey, you're not allowed to enter into any dialogue with anyone who's submitted a petition once you reject it. But how are you supposed to establish what it means in order to find out if it's submissible or not? That's why you've been given powers to summon documents or people. Oh, yes, but, I would summon you, but I'm not allowed to talk to you or respond to you directly or engage in conversation. But why are we giving the committee the powers to call the documents or people then? To find out what the petition is about, before they refer it to, whoever deals with it, oh yeah, we didn't think of that. That's a clever one, isn't it? Yes, we can call for people, documents and papers so we can really find out what this petition means. Hey, how about summoning the person who wrote it and they can tell you, no, we can't do that. I'm not allowed to speak to you, sir. I'm not allowed to speak to you. Oh, look, it's Savile Row. Yes, sir. No, sir. Suits you, sir. Why don't you change your petition, sir? Sir, you don't want brown shoes, sir. You want black shoes, sir. Yes, sir. Now, yes, sir. No, sir. This is it. No, sir, you don't want to include that evidence, sir. No, don't to prove that the sun is warm, sir. Don't include the thermometer, sir. No, sir. To prove the sun's warm, why don't you give this jelly in? Present this jelly. No, I don't want to present a jelly. How can I prove that the sun is warm with a jelly? Because it melts. Yes, but it doesn't tell me what temperature that it melts. If I've got a thermometer, then I exactly know the temperature because it tells me. This is it. Don't present the evidence that proves anything, sir. Oh, look, here's Rees-Mogg on GB News. Look, he's getting popular. Look at this. And he's getting paid for it, and it's been paid for by a private company, but he's in the election. Hey, is that making him more popular or unpopular? I've got some evidence for that. No, sir, you don't want to prove that Jacob Rees-Mogg is a criminal, sir, do you, sir? No, sir, you wouldn't want to do that, sir, would you, sir? No, why don't you instead, sir, why don't you try and get the tampon tax changed, sir? That's more interesting and useful, sir. Well, if you're a woman, if you've got a vagina, this is it. I don't have a vagina. Well, maybe you want a vagina, sir. If you could join the Liberal Democrat Party, we're trying to encourage people to have vaginas and change their sex. Why don't you support this, sir? No, actually, you telling me, listen, I'm submitting the petition, right? I decide what I'm asking for and what evidence I am submitting in this petition, right? Whether or not, you want to summarize it later after you've, established what it means, then you can summarize it how the hell you want, right? When it's still ticking down in the evidence, right? This is the thing. That's just insane, isn't it? We'll give petitions committees the powers to summon people, papers and documents so they can better understand petitions and know what they're asking. But guess what? You can't summon the person who wrote it in to tell you, because then you'll be speaking to them and then you'll be entering a debate about it. What, like Mr. Strickland did? Like Mr. George Strickland did, sir? I've never had a petition rejected in my life, sir. Never, sir. Never, sir. I'm entrusted with the faith of my electorate that have 100% confidence in me to go into that chamber and represent them. That clerk, the clerk, what did the clerk say, sir? Oh, the clerk says that you can't present that petition in here, sir. It's not right, sir. No, sir, not right. No, that's perfectly okay and acceptable. It's perfectly acceptable. This is the thing. That's Mr. Strickland. So, it makes you wonder where Strickland got his hairstyle from in Back to the Future, language, no, apparently there weren't language restrictions, but obviously you don't want to insult the members of the House of Lords, otherwise, they're not unlikely to fulfill your request. The Salisbury Plain petition was... Oh, yeah, the Salisbury... You see, the Salisbury Plain petition wasn't returned to the sender. They found it on Salisbury Plain, but clearly it was about something or someone. They didn't send it back to them, but they burned it because they couldn't find any better use for it. But it wasn't sent back to anyone. They didn't send it back or post it back to anyone. Not to be referred to government departments without house order. Right, yeah, so in the 1944 committee report, Mr. Tinker and Gilbert Campion, it was Vivek, one of the MPs who's giving evidence on the committee. He said that they were referring him to government departments directly from the committee, and he said that maybe we've been doing that wrongly and we shouldn't have been doing it. And they said, oh, yeah, well, you have been doing it wrong. So that was quite... They've admitted that they've been doing it wrong. Hey, guess what? We're Parliament, and we've been doing this thing, and we're wrong. We did it wrong. Oh, oops. But guess what? I'm honest. This is an honest report.
Look, it's Sir Gilbert Campion. You can trust him and Mr. Tinker. Look, but this, seeing that Tinker's been so honest, and Gilbert, I'll put my hands up. This is why we've been doing this wrong for all that time, referring those petitions to the departments of government who weren't even elected, and they're not even having judicial power, and they might be opposed to this petition, See, we've been doing it wrong, we won't do it again, we're sorry, but, apparently now they're asking advices from government departments. Apparently, maybe Secretary of State, it might be allowed, but, I don't know. Erskine May, rules were brand new, not traditional in the past. Yeah, so Erskine May came out with the Erskine May rules, which is not standing orders or the law, right? It's just, it's the clerk's advisory suggestions, but they don't correlate with the truth and fact of the 1832 committee report, which does suggest that the rules were a lot more relaxed and slacker. But they've said this in I think in a 1992 petitions committee report, and maybe 2004, which I haven't read one of those, but not the other one. They said they were going to relax them, but they were already relaxed. We're going to relax the rules, right? In 1994 and 2000 and was it 1991 or 1994? In the early 90s, they said they wanted to relax the rules for petitions, right? What does that mean? Going back to how they were in 1832 before Parliament burned down? But they've been relaxed. Well, Sir Erskine May tightened the rules up, and we're going to relax them back again. So, yeah, but they never were tight, supposedly. That was the clerk's advice, But you haven't relaxed them. They didn't relax them in 1994. In fact, they've never been. They're tighter than a They're tighter than a 2p Twinkie. I don't know what. They didn't. They said they claimed they were going to relax and modernize the rules. We can't have any conversation with you, even though we got the power to call for people to help find us what it's about. What's all this about? We don't understand it. Well, we'll call him in. Summon him in. No, we can't speak to you. We've been told not to in the new policy, right? I thought you were relaxing the rules. No, we told you we were relaxing the rules. We said we were relaxing the rules, but the plan was we were not relaxing the rules. We're making the rules more tight, right? Because we're relaxing the rules, we might even accept public bills through e-petitions or even election petitions, That'd be really relaxing the rules back to what it used to be in the start, And then you might have to pay the £5,000 deposit, right? Then we're really relaxing the rules. Then we're back to square one, Then we're back to 1867. 1867, someone's cheated in an election, an MP. Elections ought to be free. Well, if elections ought to be free, then if we're going to try an election, then that ought to be free as well, right? Yes, that's why it's free. We've got some strong evidence here and some signatures from the public to compel these MPs to do good justice on this, right? Oh no, but now it's there's a little bit of a price tag on that. I'm afraid it's a £5,000. All right, really. Commons petitions are not destroyed, right? So yeah, I don't think they're all burned. I think probably some of them. So whatever were in the building likely were only from that session, from that particular session of Parliament. I would have thought the particular session of 1834 from that session, and all the rest of them from previous parliaments and sessions probably didn't. So I don't know where they are if they haven't found them yet. Because I'm sure it says that they're in the Tower in that report, or they were in the Tower. Order to publish was separate from the journals and newspapers. Right, yes. So when the petitions come in, if you're arguing over a judicial matter of privilege, right, you can go yourself, right? It doesn't even need to be presented by an MP, and you can argue it, supposedly. If your MP presents it, and they back it, and they endorse it, then it's received. It's received. And then, you can argue with the clerk on your behalf. And, if the other members don't object to it or the speaker, then that's it, done. Now they can fill a form and then get the newspaper to publish it. And then it goes to the committee. Now the committee can get them. The committee can reject it if they don't know what to do with it, and then the House has to make an order to decide what to do with it, right? But they scrapped that rule so the committee could make arrangements what to do with it if they weren't sure themselves. But that was only temporary. That was only temporary at the time, so they're saying in this report, and that's been misconstrued to mean that it was like that was a resolution for permanent forever, and these are the new rules. But that's not true, according to this report. And therefore, if the petitions committee doesn't get printed, you see, everything that gets received is meant to be put down in the journal, supposedly, right? But the House can order for it to be published, but that's to be especially put out there. So there are various different, and they can write a summary or have it in full. They don't have. I mean, the petition exists, right? It's got the evidence on it, and Parliament have got it, and if they need to, try it or do a committee, right, then they can use it. But when they publish it, they're supposed to be allowed to tidy it up and make it more presentable. But that does not change the evidence, the claim or the statement which they've got. That's only so people can be informed of it, right? But sometimes they didn't change it or alter it. Sometimes they put it in full. So this is like when you're in a court, you can't alter or change evidence, right? But only certain information gets put on the court listings, and the newspapers might, turn up, and what gets put in the newspaper, they might do a sketch and put a few quotes in there from it, but they're not going to do the they don't, it's like a summary of it, it's not like they don't put the whole case files in the newspaper. I guess that's what the thinking of it is, right? But now that but now when we submit them, they're all sort of on record, even if they reject it. But there's a lot of them not getting seen. They're hiding a lot of them, so there's no transparency there. And then a lot of the ones that are rejected, there's nothing wrong with them. But it's the tag. It's like, oh, we reject this. And then it's like, if it's something that you seriously want to pursue, then what are you going to say, if you're advertising it and you get arrested and it's always rejected, it's not valid, right? It doesn't help with that. This whole rejection tag is, apparently they didn't get, well, you're not getting a resolution. You're not getting anything done about the problem, right? And apparently the whole point in Parliament is, according to some of these books that I've been looking at, is that they will find a resolution, They will find one. There must be a remedy found, or they will remedy it if it can be remediable. If it can be remedied, then they will find the remedy, supposedly. So, I mean, that's it. But now apparently everyone's saying it's been taken over by corporate infiltration. So that's kind of where I am with it. So, I don't know whether you agree with any of that, but what I'm saying is there's no doubt about the fact that anyone who reads this 1832 Select Committee report, it's painting a very different picture of what the rules were prior to Parliament burning down than to what Erskine May came out with in 1844, and that becomes the parliamentary practice, but it's only the clerks. It's like Strickland versus the clerk, right? So anyone who reads Erskine May, it's like, it's not the law, right? He's just telling you how Parliament do things, and then when people start, doing it how he says to do it, they're just like mimicking it, right? So, but it's not, the actual processes and procedures in law are in standing orders, right? They are the standing orders of Parliament, right? So, I'm not knocking clerks, but according to Strickland, he never had a petition turned away, right? Because he debated it in. And when you do e-petitions, you're not getting it debated in by your MP, or if they are, they're not doing as much of a good job as Strickland was, because he had an impeccable record, right? Strickland had an impeccable record. We're not getting chance to speak. I don't know if they're doing it on the basis that we're not allowed to speak, right? But actually that's wrong, because that's only like, the MP can present it and speak, but then when once it gets referred to the committee, then they can summon people in and call for people and papers so they can understand it better, right? But they don't want to call us in or understand it. They just want to look at it and then use their own I don't know what, but they don't want to use those powers. That's what those powers are for. That's meant to be what the powers for that committee are for. And I don't know what happens when you procure those debates and all these different MPs coming from Parliament, if they want to participate in it and try prove something, what powers they're using for documents then. But I don't think they're that petitions committee powers, because then they're looking into the matter. They're just using their own, I'm an MP, type thing, surely. Or that they've, it's not the petitions committee. According to the 1973 report, they're only going to be able to call for papers and powers that committee to understand it. And then once they refer it to a different committee, then that committee can investigate and take action on it, or wherever it gets, whatever ministers or it gets sent to. Or if the House ordered that it be sent to a Department of Government. But at the moment, these other government departments, apparently these 4 persons are asking them for advice. And then the government departments are coming back and boo-booing us and saying, no, they can't do that. Well, just, no. You don't tell me what I can and can't do, right? Because I didn't elect you, and you're not sworn in on oath, and you're not the High Court of Parliament, right? You're a department of government, a civil servant, right? This is the thing, and I'm opposed to you, and I'm going to shut down your entire department. That's what the petition is, right? Hey, look, let's close down the Department of Transport. Oh, well, we asked them, and they said you can't have that. Oh, well, unbelievable. I can't have that. Well, they wouldn't be able to have the department when it's closed down, will they? No, but they said that you can't run that petition. We can't shut down the Department of Transport. Well, we can. Well, the MPs will be the deciders of that, Mr. Strickland will be the decider of that. This is the thing. So, at the moment, 2010, 4 people deciding, getting paid £200,000 a year, when clerks used to get paid, like tuppence, tuppence for 10,000 petitions, signatures checked. It's probably it's worse than Mogg on his £80,000 a day, whatever he's on. I don't know what he does with that, whether he goes to Costa Coffee or eats gold-plated donuts. I'm not sure, but Mogg's a criminal. This is the thing, he was made popular by private money while he was running for election, including in his own constituency, and given free entertainment through YouTube. And it didn't work out for him. People boo-booed it because it affected the election one way or another, which is not allowed to do. So, something needs to be done about some of these MPs. And we would be able to do something about them if we could get these petitions. We've been turned into the triers of petitions who don't have any judicial authority. Petition triers are actually people trying to get petitions in. That's the joke. Do you like our little joke? Petition triers, people, public petition triers. Oh, you're trying to get those petitions published. Oh, what a shame. If only you were the real triers of the petitions, and then you'll be actually deciding what happens with them and what gets done, So, it's just insulting to have this tag on it that is rejected or whatever, and all these ridiculous excuses which cannot hold up to any of this AIM 32 evidence, because particularly on the language and where it can and can't fit in. There's a lot of those, the rejected ones that can be run. That's for sure. I've looked through them, and every single one of those. It's like I'm doing the Strickland job. When I go through, these are the ones that even show you. They don't even show you all of them, right? They don't see like a quarter of them. Can't be that bad, surely. Get Keir Starmer to wear a rubber duck and swim the channel. Then we can't see that one. No one to see that. It's defamatory. Or something like that. But it's Starmer to have a tea party with Macron. The House of Commons to hold a Mad Hatter's tea party in the chamber in secret. With the cheeky girls in a petition. Who can't see that one? This is it. So yeah, I mean, those ones that they do publish, which they reject, at least. I mean, I could go through those like Strickland, and that I've looked through them. I've looked through them, and that's a Strickland job. But we don't have. If only they made them. They don't make them like they used to. We don't have any Strickland. We don't have any George Stricklands anymore, and we don't have any Mr. Tinkers anymore. Unfortunately, we've got MPs, Mr. Matt Franchise. I don't know. We've got Ed Davey. Ed Davey. We've got MPs. So, not happy with e-petitions at all. Not after reading this 1832 paper. I don't think that the current policy is constitutionally sound. And they're just, we're going to relax the rules. No. This is not relaxing the rules, right? I haven't had one petition published this year. None. It is now August. They started it in the end of October, right? And we're nearly back round to the end of October again now. I haven't had one published. Not one. And half of these people who do these petitions aren't that interested in it. I'm not on the university course, and I aren't a professor in early modern history, right? But I know what it is. I've read a lot more than the average person, for sure. And most people, when you go in these groups who are signing them, don't really know. So I don't know if it's just a symbolic. I don't know what they're doing. Who wants the rejected tag on there? It's almost like Big Bertha, or it's like the Raggy Dolls. It feels like you come home from school and then you're watching the Raggy Dolls. The Raggy Dolls, they're happy just to be Raggy Dolls. The Raggy Dolls, those like you and me. Chuck them in the reject bin. I don't want to be we don't want to be in the reject bin. But this is like the MPs. Oh, we don't want to be in the reject bin. Nigel Farage doesn't want to be in the reject bin. Well, yeah, but you shouldn't break the law, then, should you? This is the redress of the grievance. This is the thing. We're here for complaining. He must grumble. This is the thing. It's almost kind of like it's like Fight Club, isn't it? The one rule of Fight Club: you've got to fight. Hey, guess what? There's one rule in public petitions: you've got to have a grievance. Must grumble. The one thing about public petitions you've got to do, what's that? Must grumble. This is the thing. Well, no, we're here to change the tampon tax. No, we're not. Why did she even... something, right? Why was she allowed to run that tampon tax petition as a public petition anyway? Because if she's wanting to get legislation changed, shouldn't that go through private bills? Because private bill, if you're a private person and you want to get tax changed, well, no, we're getting it changed for the public, on behalf of all people, all the public, right? But some of those private bills are getting certain acts changed for particular companies or to benefit particular companies or whatever. It's not just like, my company is allowed to, fish on, Bill Gates's, back garden or something, or I can fly my plane over, I don't know, Rod Stewart's railway track or something like that. And this is the thing. It's if you want to get tampon tax changed, right, that is more to do with legislation, right? What is public petitions even for now? What they're kind of doing is, like, all these people are doing private bills to get laws made, right? They've set up public petitions to sort of be like that, but for tinkering around with it. Like, change tampon tax up or down. In fact, she wouldn't have been able to do that tampon tax law previously because they didn't allow you to... It was concerning public money, right? Taxing, and you had to get royal consent. This is to do with, like, the pensions tax. This is like Starmer's pension plan, right? Because there was a pension petition about pensions, and they won't let them do it because it was involving public money, and they had to get royal consent. But then they said that if it involves legislation, you're allowed to do it, right? So if it's like, if the government, if I want the government owe me money, like compensation or injury, then I've got to get a referral, right? Because it's public money. But if it concerns an act of law that you're going to get put through, then you don't anymore. So that's the only reason they can do the tampon tax, because it's like, it's to do with revenue, right? And that's kind of like the joke with this tampon tax thing. It's like multiple aspects to it. It's also legislative. So I really don't know why they split off all these public bills and made a whole separate process for it, preparing, sponsoring public bills, blah, blah, blah. Because they're meant to be able to make a legislative resolution for any of the grievances, really, supposedly, you can. So that means that you can ask for it, So, what else can I say? I want to actually get hold of those 20,000 petitions that mention protections and privileges now, and have a look through them to see if people were using that process that Mr. Tinker talked about, or at least complaining to Parliament, otherwise through their MPs about, doing remonstrations in public and getting the police intervening or whatever. Have a look what's what and see what sort of people were saying about it. That's the main thing that I need to do now. And there's probably, a dozen more reports that I could probably do with reading, but they're all more the modern ones. All these more recent ones a lot of them are tosh. As you say, the Privileges report does not mention any of the 5 Privileges Acts, and every time they mention the Bill of Rights, they're using Erskine May. I noticed they do that. Well, that's not the Bill of Rights. You haven't mentioned the Bill of Rights. You mentioned Erskine May's interpretation of the Bill of Rights through every single report. It's almost like that you would like that to be the Bill of Rights, what Erskine May said, right? That's like a clerk, his advice is now the law. No, it's not. The clerk's advice is not the law, right? The law is the law, which is the act which the MPs voted through, right? Yeah, and this is how they're getting this facade of Erskine May's like the Parliamentary Privilege Book, his best advice. No, Strickland says otherwise, right? No, Strickland says illegal prosecutions in the King's Bench for matters cognisable only in Parliament and other diverse and arbitrary causes, right? That is Article 9, right? If you tell me Article 9 is a opinion of the Clerk of Parliament and put it in the book with Article 9 written over the top of it, as if it's some fucking William Penn plaque in the fucking Old Bailey, right? You are misleading people and trying to deceive them. That is a crime. That is a criminal act in Parliament. And, apparently no court out of Parliament can decide on that, which is why we're petitioning for it. Let's send the Speaker to the bar in the House of Lords. Let's get them impeached. Let's do it. You know, oh, we'll have to hold it in the Supreme Court. Well, that's a good idea. This is the thing, you know. Or apparently if it's treason, it can be prosecuted in the courts. But, you know, Tony Blair's taking away the death penalty. Apparently there's no fun in that anymore, you know. In fact, we could do with Tony Blair being impeached because, you know, Tony Blair's broken that many laws. I think he's got the world record now. Tony Blair, he's got all the attorney generals in illegally. Conflict of privilege. He set the judicial oath against each other, deals for justice. He referred petitions directly to government departments from number 10, which you can't do without order of the House. And what else? War crimes. You know, Tony Blair is like record breakers. Well, he's broken records, you know, and then you got Gordon Brown, you know, breaking, oh, let's scrap this constitution, let's scrap this resolution in Parliament business, you know. It's like, you know, we'll have tries of petitions. You know, petitions ought to be free. No, the Supreme Court's not free. You know, where's your £5,000 deposit, you know, or whatever it is. I don't even know how much it is for the Supreme Court. I dread to think, but you've got to work your way up to it. You can't just, like, you know, chuck it to petition to House of Lords. But there's meant to be a bit of error, isn't it? This is the thing. I think that's it. So, must grumble, more things to read. There's always more things to read.